Schedule 1 to the Re-Re-Amended Particulars of Standard Chartered Plc.
Good morning, my lords. I appear on behalf of the Appellant, Standard Chartered Plc, with my own friend, Mr. Dominic Kennelly. My own friends, Mr. Shell Patel, KC, and Mr. William Harman appear on behalf of the claimant. As your lordships know, this is an appeal against the order of Mr. Justice Michael Green of the 4th of August of this year, by which the judge dismissed our application to dispense with disclosure of certain documents that are subject to foreign law restrictions, unless until the relevant foreign regulators authorise such disclosure. As your lordships will have seen from our skeleton, there are now 2 remaining categories of documents that are affected by the application and this appeal. The first of those are the US SAR documents, as we've called them. That is, documents comprising US suspicious activity reports filed by the New York branch of Standard Chartered Bank, of which there are 4 on a standalone basis, and other documents that refer to these or other US SARs filed by the bank's New York branch. The principal regulator in relation to this category of documents is the Financial Crime Enforcement Network of the US Department of Treasury, or FinCEN, and although it's been sought, FinCEN's consent to the disclosure has not been forthcoming. There's no dispute between the parties that it is unlawful under US law to disclose those documents without the consent of FinCEN. And there's also no dispute that criminal or civil sanctions are potentially attached to unauthorised disclosure, although as you lordships will appreciate there's a dispute as to how great that risk is. The second category of documents are those which we call the CSI documents. That's to say documents containing what is called confidential supervisory information, or CSI, under US law. CSI is a form of property of the regulators under US law. And in this case, the 2 regulators are the Board of Governors of the Federal Reserve Bank and the Federal Reserve Bank of New York, to which I refer as the Fed collectively, and the New York Department of Financial Services, the DFS. And again, there's no dispute that US law prohibits the disclosure of those documents without the consent, as the case may be of the relevant regulators. Our skeleton at paragraph 3 recorded that the appeal affected in total around 160 documents out of the total disclosure given by Standard Chartered of around 50,000 documents. I have a small update to give your lordships about that. I understand that the figure for unique documents has slightly increased to 176, so an increase of 16, as a result of further checks by Standard Chartered's legal team since the hearing of this application. That comprises 16 US SAR documents and 162 CSI documents, with an overlap of 2 documents between those 2 categories. For completeness, the total number of documents, including duplicates or near duplicates, is 1,774, just so you have the 2 figures to hand. By way of overview, our core submission is that the judge seriously erred in this case in failing properly to apply the guidance of this court in 2 cases, the first being National Crime Agency and Abacha, and the second being Bank Mellat and HM Treasury. We say with respect that the judge went wrong at every stage of the analysis and in a number of different respects. And I'll develop our detailed criticism of the judge's approach and reasoning in my submissions this morning. But the starting point, we say, is that Abacha and Bank Mellat, taken together, make clear that an order for disclosure will not be lightly made where it involved the breach of duties of confidence owed to foreign governments, or in this case, foreign regulators, that arise under foreign laws. And that will be particularly, albeit not exclusively so, where breach of foreign law would expose a party to prosecution or other sanction in that foreign jurisdiction. In short, we say the judge set the threshold for granting Standard Chartered's application far too high. As I've said at the outset, it was common ground that Standard Chartered owes strict duties of confidentiality under US law to the US regulators in relation to the affected documents, and the disclosure without the consent of the relevant US regulators would be unlawful as a matter of US law. And we say that fact alone means that this case is distinguishable from the vast majority of the other cases that are in the authorities bundle, in which the court found either that the foreign law wasn't engaged at all, or that it was a dead letter, like the French blocking statute or something of that type.
What does that mean, dead letter?
In the sense that it simply has not been enforced at all. So if you take the French blocking statute cases, in many of those cases, it's accepted that there is a technical breach because it's so widely drawn. But the only ever example of a prosecution in relation to that was one prosecution ever, I think, of a lawyer who had effectively done something against his client's interests in terms of disclosing the document. So it was, and even the recent cases in relation to the French blocking statute, like Joshua and Renault, say that even despite growing executive interest in perhaps the greater use of that law, but it hasn't generated any change in prosecutorial approach. So that I put it together that French blocking statute cases I accept are ones where it was within the scope of the law and that was accepted, but it's a case where the English court has said this is a law which has no teeth whatsoever. That was my point really in relation to that. So in relation to the US SAR documents, we maintain that the judge plainly erred in his assessment of the risk of prosecution or other sanction. We do say that the judge effectively treated it as determinative, but Standard Chartered was unable to point to previous examples of prosecutions for unlawful and unauthorised disclosure in breach of a foreign court order. But the judge took that view despite the uncontested evidence of US law in relation to US SARs, that our US SARs expert was unaware of any previous examples of disclosure of US SARs ever having been ordered by a US or foreign court, given the strict confidentiality that attaches to them. Nor was he aware of unauthorised disclosure ever having been given pursuant to such orders, and so it logically followed that there would be no such prosecutions. The judge in our submission therefore set the test at a level which it could never be satisfied in the first case where a conflict arose between disclosure and this or any other foreign law restriction. And to compound matters, we say that the judge then gave no freestanding consideration in his analysis to the fact that both the US SAR documents and the CSI documents are subject to strict duties of confidentiality owed to a public body, admittedly a foreign public body, but duties that are owed in the public interest that comity required to be given proper weight, irrespective of any risk of prosecution or other sanction. And we also say that the judge didn't undertake any proper analysis of the importance of the documents to a fair trial. Regarding it, we say, as sufficient that they crossed the threshold for disclosure and not engaging with a more critical analysis of whether or not these documents were likely to be important for a fair trial in the context of the case as a whole.
Can I just understand what you mean by comity?
Yes.
I mean, do you mean that English courts should give a degree of deference or certainly understanding to foreign regulators? Or are you saying that we should do to them that which we would hope should be done to our regulators if the boot was on the other foot? What do you mean by comity? It's a very broad word.
It is. It's a little bit of both, if I may say. The starting point, as I'll show you, Lordship, in relation to a batcher in a moment, is that confidentiality generally is a factor that goes into the discretionary exercise that the court does when deciding whether to order disclosure, balancing that against the importance of the documents for a fair trial. And so, in principle at least, even, for example, private law obligations of confidentiality, certainly when combined with other factors, may justify some kind of restriction on disclosure. That would be a rare case we would accept. But when one moves to the public sphere, where you have a public body in a foreign jurisdiction that is owed under the relevant law duties of confidence, backed up by foreign law and backed up by a public interest, that the English court is entitled to and should, we say, take account of that, the existence of that obligation, that confidentiality obligation owed to a foreign public body, and the public interest that underlies it. And in those circumstances, even if it can't be established, for example, that the foreign regulator would visit a criminal or other regulatory sanction on the disclosing party, that underlying public interest if it is one that the English court considers is sufficient weighty in the circumstances of the case, is one that should factor in the balance as a matter of comity in terms of respect to the foreign regulator and the foreign legal system. But it also has this the further point, which I do submit is important, which is when you have highly regulated global financial institutions, many of which are based in the UK or certainly have branches in the UK, it is inevitable that A, they will have regulatory relationships with foreign regulators around the world, and B, that they may get involved in litigation in many different jurisdictions around the world. Most usually their home jurisdiction, but it's possible for litigation to take place elsewhere. And in those circumstances, there is also a do as you would be done by point, which is if you extrapolate out that there are confidentiality obligations owed under English law under the Financial Services and Markets Act to the FCA and the PRA in relation to certain categories of documents. They're not identical to the restrictions in the US, but they serve a similar public interest function, as has been recognised in the English cases. And we do submit that there is a point that if litigation were to occur abroad, in circumstances where regulatory communications could attract a duty of confidence under English law to the FCA or the PRA were to be relevant and potentially disclosable. But there is a point that no doubt the FCA would hope, at least, perhaps expect, that the foreign court would take into account its legitimate public interest in protecting the confidentiality of that information and the non-disclosability of that information.
Was there any evidence of any of that?
Of the FCA's?
Of any of this sort of mutual comity or mutual expectations of the UK regulators?
There's no
of any foreign court, for example, ordering disclosure or non-disclosure because of a UK obligation of confidence. I mean, is this just left sort of hanging in the air for the court to make some judgment on of its own volition, or is there actually something upon which the court can actually act?
There isn't any evidence on that, my lord.
How can you run the point?
Our submission is that this isn't really a point for evidence in the sense that the fact is that there
we have to take judicial notice of the attitude of regulators across the world.
No, my lord. The point that I'm making, for example, in relation to the FCA, is that there are statutory restrictions in law which has been recognised in the English cases as having a public interest. And the simple point I'm making is that if the English court takes no notice of the broader public interest, of which there is evidence, the actual public interest factors that underlie the US restrictions are in evidence, and one sees that in for example, the US and the Fed and DFS letters. It's a simple point of if one cannot expect the restrictions that exist under UK law to have that exist in the public interest to be given weight in foreign jurisdictions if the English courts are not willing to do the same here. Now I appreciate that this isn't a point we run on the basis that the FCA has a certain expectation or hope or belief. We don't seek to run that factually. We're saying simply that one can take judicial notice of the legal point, but there are these restrictions that exist under English law, and that they reflect an important public interest that exists under English public policy.
Can I briefly go off to tangent,
Yeah.
not having looked at the relevant cases for a long time? Suppose this were all domestic and we were concerned with communications you had made to the FCA or the PRA, and you wanted to withhold those now, what would the position be in English law?
So in the closest authorities that we see are Bearings and the real estate opportunities cases, which are in the bundle. And insofar as it is a matter of English law, it's quite clear that if it were unlawful as a matter of English law to disclose it, so within the scope of the criminal offence under what is now the Financial Services and Markets Act, that no order for disclosure would be made. So that, but there is that, and I fully accept there is a distinction which goes back, which one sees in the Morris case amidst Justice Newberg, that the English courts will not order a party to do something that is contrary to English law, and it inevitably comes to discretion if you're dealing with what one does about foreign legal restrictions. I totally accept that point.
Yeah.
But my straightforward point is that I accept comity is a notion that the court is slightly elusive. And I would respectfully submit is not conducive necessarily to being evidenced. And it doesn't, and I certainly don't found it on saying that the head of the FCA or the head of the PRA has this factual expectation. All I'm saying is that in international litigation and in context of international businesses, there is a clash of jurisdictions where different public interests recognising those different systems laws come together, and where that happens, it is well established from, for example, Abacha and from Bank Mellor, but the court does not take an entirely sort of parochial insular view and does look at the public interest beyond that.
Yeah, no, but even accepting as your proposition that this is discretionary, where there are foreign regulatory considerations involved, I'm really just trying to test for a moment about how the court exercises its discretion and on the basis of what evidence. Because speaking at least myself, it's a little unsatisfactory for a court to be told, well, there are these considerations of comity, whatever that means, that you should take into account, but without any real basis to be able to weigh them or assess them without evidence, because judges are not regulators. Judges don't work in the international regulatory network. I know there is one, but I'm not in it. And just as a matter of how to exercise a judicial discretion, why is this an area that the judge is expected to do it without any underlying material?
I wouldn't quite accept that you're doing it without, you'll be asked to do it without any underlying material. In terms of what is evidenced, one has your logics have the evidence of the foreign law restrictions, and as you'd expect, that has to be evidence that's outside the scope of the English.
Did the evidence of the experts go to this question of expectations of regulators in different jurisdictions and quotes comity unquotes?
Not in that sort of ultimate question sense, no. But what it did cover was the underlying rationale, the public interest rationale, the reason why these restrictions exist under the foreign legal system, the importance of for example, CSI to the regulators, and why it's been regarded in the US legal system as being important, and that is all evidenced. And what we say is that when the English court can look at that evidence, consider how those public interest rationales chime with what it knows about the UK legal system and recognised in domestic cases about for example, in this context, the importance of confidentiality of bank supervision, and can ask well that public interest, albeit as a foreign public interest because it's a foreign regulatory relationship, reflects a public policy that we also find in English law, and in doing that, the English court can say, well, that therefore is as a matter of comity, we are willing to take into account that foreign public policy on the basis that it is engaged by English litigation and international world.
No, I was only going to say, I think you're going to run into time trouble if we distract you for too long, so you probably better go back to where you intended to be in your submissions.
I'm grateful, but I think that was been helpful
Yes.
to try and tease that out. I can probably take the comity points later on a bit more quickly. just to wrap up on where I in my overview of where we say the judge went wrong, we also say that he didn't give any proper analysis to the importance of the documents to a fair trial. We say regarding as sufficient, but they merely crossed the threshold for disclosure and not going into greater analysis. And then we also say that he proceeded on the basis that in the balancing exercise, the scales are weighted down in favour of ordering disclosure. In terms of timings, as my Lord Justice Newey just alluded to, as you also know, we have 1 day for this appeal. I've discussed and agreed a division of time with my old friend, Mr. Patel. I anticipate that I'll be on my feet until no later than 1 p.m, so until lunchtime. My old friend will then make his submissions in the afternoon, hopefully leaving a short amount of time at the end of the day for me to make some reply submissions if I need to.
Sounds very sensible.
In terms of roadmap for my oral submissions, what I propose to do is, first of all, briefly say a little bit about the claims in the proceedings, so far as that's relevant to the issues on the appeal. Second, I want to take your lordship to the two key decisions of this court, which, as I've said before, are Abacha and Bank Mellat. Third, I'll present our submissions on the US SAR documents. And then fourth, I'll turn to address the CSI documents, which, as your lordships will have seen, that appeal is now maintained on the narrower basis than the US SAR documents, the comity point that I've just been debating. So turning straight to the details of or more detail on the claim, your lordships have the case memo, which is probably the best sort. I'm not proposing we turn it up, but in case it's useful, it's probably the best source of just the overview that your lordships may need of the facts. So that's supplemental bundle tab 3, page 6. As your lordships will have seen, the claimants advance two broad claims. One is under section 90A and schedule 10A of the Financial Services and Markets Act 2000, and the other is under section 90 of the same act. And in broad terms, for their section 90A schedule 10A claims, the claimants allege that from 2007, Standard Chartered's published information contained untrue and misleading statements or omissions regarding Standard Chartered Bank's compliance with Iranian sanctions and the adequacy of its financial crime and AML controls, anti-money laundering controls. And that certain PDMRs, that is, persons discharging managerial responsibilities, acted fraudulently, knowing of those inaccurate or misleading statements or omissions. For their Section 90 claims, the claimants allege that 3 prospectuses for rights issues in 2008, 2010, and 2015 contained the same untrue and misleading statements or omissions. In terms of the facts, as your lordships will know, Standard Chartered Plc is the parent company of Standard Chartered Bank, and the bank operates as a global retail, wholesale and investment banking business through a network of branches around the world and subsidiaries, including a branch in New York, and also, as far as material for present purposes, also operates in the UAE, in particular Dubai. By way of background, in 2012, the bank entered into a regulatory settlement with the US authorities, including the Fed and DFS, with respect to breaches of US law concerning sanctions on various countries, including Iran, between 2001 and 2007. And the 2012 settlement related in particular to the removal of details of customers identified as being from sanctioned countries such as Iran from payment messages that were processed through the US. As part of the 2012 settlement, the bank entered into a DPA with the US prosecutors and also agreed to the appointment of a DFS monitor to oversee the bank's systems and controls remediation program. The monitor has some significance because one of the categories of documents in this case relates to communications with the monitor. And as I say, they were appointed to oversee the remediation program as part of the 2012 settlements. The claimants' claims in these proceedings are not directly concerned with the misconduct that was admitted as part of the 2012 settlements. Instead, the claimants rely on further misconduct that was admitted by the bank in settlements entered into with the US authorities and the FCA in 2019. And importantly, we say that the findings in the 2019 settlements didn't concern any misconduct that took place at the New York branch of the bank. The connection with the New York branch comes from the fact that it processed payments in US dollars that were sent elsewhere from within the bank. And it's not suggested, we submit, in the 2019 findings, I don't think this is disputed, but there had been any relevant systems failures or shortcomings at the New York branch. The 2019 findings instead concerned misconduct by certain UAE branch employees and also financial crime control and customer due diligence failings in the bank's UAE Dubai branch and the correspondent banking business of the bank's UK wholesale bank. And in broad summary, what those findings involved were that those parts of the banks didn't do enough to identify, record, and monitor the Iranian connections of some of its customers and to prevent its customers from making payment instructions from Iran through its internet banking systems or by fax, as a result of which the bank did business in breach of US sanctions with those customers who it had failed to identify in its systems as being based in Iran or who were fronts for such persons. The claimants also make further allegations that the bank engaged in the deliberate and systemic evasion of Iranian sanctions. Those are referred to as the Brutus allegations because they were first advanced in proceedings in the US by an entity called Brutus Trading, and they have been adopted in part by the claimants in these proceedings. Those allegations are strenuously disputed by SC and the bank. Your Lordships may have seen that they were fully investigated by the US authorities and were found following that investigation to be meritless, such that the US proceedings brought by Brutus were in fact dismissed in 2020 on a motion brought by the US Department of Justice. Then finally on the claim, just for the sake of completeness, I should say the claimants also advanced a further limit of their case by reference to an alleged bribery scheme as a Singapore entity in which the bank held a minority shareholding. That part of the case is not of any relevance to the documents in issue on this appeal, so I don't say anything about it, I'm just mentioning it so your Lordship has a complete picture of the scope of the claim.
Just on the Brutus allegations point, notwithstanding the dismissal of that case in the US, as I understand it, the claimants are still alleging the same allegations as were made in that case. Is that right?
I understand they've adopted parts of the complaint, yes. So although they've been dismissed in the US, the claimant's position is that they are nevertheless true.
So in terms of the issues in the UK, in this case, those are contested issues, as if the allegations have been made as primary allegations here, and are denied by your
Yes, as things stand, those are live issues. The claimants are due to replead at the end of next week, so we wait to see whether they're abandoned following disclosure, but if not, yes.
And those are about a broader systemic breaches of sanctions. Is that right?
Effectively, it's suggested that there was a deliberate plan to evade Iranian sanctions. So as opposed to some misconduct by lower level employees at the Dubai branch and systems and controls failings applicable to that branch in the UK wholesale bank correspondent banking business, but there was essentially an overarching conspiracy, and that we just say there's no evidence for it and it's denied, and the US authorities have come to the same conclusion.
So the US authorities came to this conclusion on the merits.
Yes, they investigated the allegations and they've sought to have the allegation, the proceedings in the US dismissed. But I accept my Lord Justice Miles' point is correct. It's a live issue as to whether or not that happened as things stand on the pleading.
And was the allegation that it went right to the top?
I'm not sure it's that clearly particularised, my Lord. I think there are certain individuals are identified who are more senior individuals in the bank. Yes, but I'm not sure it's.
And are they PDMRs?
I might just have to check my Lord. Yes, some of them, yes. With that overview of the claim, if I may just now turn to National Crime Agency in Abacha and Bank Mellor, as those are the two key decisions that are relevant to this appeal. If we could start with Abacha, because it's the first in time, which is in the Authorities Bundle, tab 5, page 73. Your Lordships may know this already, but just by way of brief summary of the circumstances, the case concerned a request for legal assistance to the UK National Crime Agency from the US Department of Justice in support of civil forfeiture proceedings in the United States. The English court, High Court, the first instance, made a prohibition order preventing dealing with specified assets in England and Wales. And the respondents to that order sought to inspect the request made by the US Department of Justice to the National Crime Agency, so a request for mutual legal assistance, ostensibly for the purpose of testing whether the property in question was relevant property under the applicable legislation, and thus whether the English court had jurisdiction to make the order in respect of the property that had been frozen. At first instance, inspection was refused on the grounds that inspection wasn't necessary for the just dispose of the proceedings, and accordingly there were no considerations of justice that trumped the expectation of confidentiality in communications between states. And then on appeal, this court took what might be called a more nuanced approach and allowed the appeal in part. It's important at the outset, in our submission, to note that this was a case concerned with confidentiality alone. That is, there's no question of the risk of prosecution or other sanction abroad. Indeed, the US Department of Justice, through the NCA, was in effect the applicant for the prohibition order. The judgment of the court was given by Lord Justice Gross, who, as we shall see in a moment, was also giving the court's judgment in Bank Malat. And if I could ask your lordships to turn up, first of all, paragraph 31 at page 82. And we rely on and draw your attention to the reference in that paragraph to confidentiality, where it is asserted being a relevant factor to be taken into account by the court in determining whether or not to order inspection. And then this broader statement of principle that the court's task is to strike a just balance between the competing interests involved. Those of the party asserting the entitlement to inspect the documents, and those of the party claiming confidentiality of the documents. In striking that balance in the exercise of discretion, the court may properly have regard to the question of whether inspection of documents is necessary for disposing fairly of the proceedings in question. And we submit that that is a generally applicable statement of principle. One can then see how it's applied in this case if one moves on in the judgment to paragraph 47, page 87. If I could ask your lordships just to read paragraphs 47 to 48, we highlight in particular the fact that it's said that a careful balance needs to be struck between the strong and legitimate interest in confidentiality, and also that it's right to start from the position that letters of request, such as the request, are confidential.
This is a case where of mutual assistance requests made by one state to another, and there was a treaty under which the requested state agreed to keep the request confidential, so that the UK in this case had a treaty obligation to keep the request confidential. Is that right?
Yes. So if one goes,
I see that he refers to the treaty in paragraph 48.
I think if you want to see the reference, it's paragraph 7, my lord, of the judgment, page 77. One sees Article 7 of the treaty, and your lordship's quite right to make that point. And so I'm not saying that Abacha is on all fours for this case, but there is an international law obligation assumed by the United Kingdom towards the United States in relation to the confidentiality of this request. I accept that.
So one can readily see the English court saying, well, its interest of maintaining confidentiality is important. Is there any case where the English court has said that its function is to give effect to what I think you've called the public policy of a foreign jurisdiction.
We haven't identified a case where that point has arisen squarely. So that it's but we do say that that one can take into account foreign law duties of confidence and the public interest that underlies them. It goes back to the discussion I was having with my Lord Justice Snowden about the fact that the public interest that underlies all of these regulatory regimes is around the world is broadly analogous, albeit the way in which the balance is struck in different jurisdictions may be slightly different. And does the English court's ability to take into account that public interest in the context of a global financial institution that is regulated in numerous jurisdictions around the world, does its ability to take into account that public interest stop at the border of the United Kingdom, or does the fact that there's the same public interest or very similar public interest issues are engaged with the similar confidentiality regimes in other jurisdictions need to be taken into account by the English court when it comes to determining whether or not to order confidentiality? Order disclosure. I accept it's not the same question as was considered in Abacha because one doesn't have that treaty obligation. But what one does see is a coalescence of ideas within regulatory regimes, which by definition operate within their own borders.
Isn't there a principle of conflict of laws that the English court won't give effect to the public policy of foreign jurisdictions, or am I misremembering that?
I'm not sure it's quite that stark.
Well, I've probably overstated it, but there's a.
I mean, there are cases, for example, like Lamenda, which concerns enforcement of contracts. So it's quite a long way off this situation where you have Qatari public policy and English public policy and an English law governed contract in which Qatari public policy is taken into account because it chimes with the English public policy. But I think it's not quite as stark as the English court can take no account of foreign public policy, but I accept fully that it plainly is not the case that the English court must accept a foreign public policy. That plainly can't be the law. All we're saying is that in the context of the court exercising its procedural jurisdiction in relation to disclosure, which we accept is governed by English law as the lex fori, it's legitimate for English law, and not just legitimate, but essential for English law to take into account confidentiality obligations which are of like nature to the ones which it would take account of if they arose under English law when deciding whether or not to order disclosure. The only reason in it...
confidentiality per se is not a reason not to order disclosure.
No, but when backed up by a public interest that the English court recognises as one that is merits exercising its discretion not to order disclosure, that it can do so.
So you're saying what, as far as disclosure to regulators are concerned, that's a sort of enhanced duty of confidence?
Certainly over and above, for example, a duty of confidence that arises in private law, for example. It's a public law duty, or duty owed to a public body.
So we could take my Lord Justice Newey's point. If this was all occurring in the UK, we could look at the English statute, we could look at the English regulatory structure as part of our domestic law, and we're very accustomed to doing that, and discern from that a public policy which enhances duties of confidence. How do we do it in relation to a foreign regime? You have to do it on the basis of some evidence. I'm not suggesting we shouldn't be taking into account, don't get me wrong. I'm just querying, how do you do it as a judge? Don't you need some evidence of...
What I would say is one needs evidence of what the foreign regime is and what the policy considerations are that underlie that regime, which one does have in this case. What it's then for the English court to do is to assess what weight should be given in the circumstances of the case.
It's that weighing that I'm concerned about, because you just use the word comity and you just stick the label comity on it and then say, hey, presto, you can do it. And I'm just trying to tease out how evidentially we weigh. I mean, do we, for example, give the same weight, if it's a weighing thing, to a regulator in the US as we would give to a regulator in Russia?
I mean, I think there are a whole range of different factual distinctions that could be said, but in principle,
How do we do it? Do we just have to do it off our own bat with a blank bit of paper in front of us,
I mean,
or do we rely on evidence to do it?
I mean, I would say one relies on evidence as to what the rationale of what the foreign law duties are and what the public policy in the US in this instance is. The court can then assess whether that is a public policy that chimes with the public policy of the forum, which we submit it does. Effectively, the only these are very, very similar regulatory restrictions to the ones that one sees under UK law. But the reason why they arise under foreign law is because Standard Chartered Plc is the UK-based holding company of a global bank, necessarily has regulatory relationships which bring into play lots of different jurisdictions, and where it may well be sued in England as its home jurisdiction, but where documents generated in the course of its global operations may arise actually outside the remit of the UK regulatory regime, but within the remit of the foreign one.
Yeah,
And so the English court needs to find a way of accommodating that, because
would we give the same weight? I use the word weight. I'm not sure it's actually a weight, but I'm using it just as a shorthand. Do we give the same weight to the regulatory regime in every foreign jurisdiction in which Standard Chartered operates?
in principle, yes. I think I wouldn't shy away from that position, subject to this point, which is that the court would expect to receive evidence as to what that regulatory regime is and what the public policy behind it is, and could form an assessment of whether or not that is, if the regime is regarded as some sort of extravagant regime of confidentiality that sees no analogue in the English system. The English court may come to the view that goes beyond what it's willing to countenance in terms of giving respect to, via comity, to foreign duties of confidence. But that's not what we see here. We see a regulatory regime that restricts the disclosure of suspicious activity reports. One has a very similar regime under the Proceeds of Crime Act in relation to UK ones. And you have confidential supervisory information similar.
I mean, I understand you say this is the paradigm. If there is comity or whatever it means, this is a paradigm case for it. But I'm just trying to push you a little bit because, as I say, you sort of label it comity, which is often used as a cover for a sort of intellectual or evidential exercise, which I'm just trying to get to the bottom of.
I use comity because it's the word that picks up in the cases both Abacha and Bank Mellet. But I think if I was stepping back and putting a bit more flesh on the bones of what comity means, what we're saying is that where duties of confidence are backed up by a public interest rationale that is evidenced in a foreign jurisdiction, then the English court is entitled to look at that and give.
Because you say in relation to the CSI documents, as I understand it, this alone would justify the court declining to order disclosure.
Yes, in the circumstance of this case, yes. When one weighs it against the relative
unemployment. So I'm teasing you as to whether, teasing out whether, although you may think I've spoken, that this is for. Is this the case for every foreign regulator that has a similar sort of regime? And I'm just trying to understand how the judge sitting practically there does this without evidence or.
But yes, I think I've made the point already. But I think the point is that the evidence has to be of the foreign. What has to establish what the foreign regime is and what the public interest is that's being served and so on. And the English court then is in a position to take.
We don't need to know what the English regulator thinks about the foreign regime or regulator.
I suggest you don't need to. Don't need. If I could then.
Sorry, no. You're asking rather questions, but
no, it's fine.
The impression I've got is that when you went to the judge to ask for this withholding order, it was on the basis of a risk of some sanction.
Yes.
And that was how the a judge addressed it, and that's how Mr. Lewis put it in his evidence. Was this point about what I call the comity point a separate ground?
It was put as a separate ground, yes, below as a separate freestanding point. I think it's right to say that the focus below of the argument was on the risk of prosecution and sanction. And in relation to the USR documents, it still is. And I do want to develop my submissions in relation to that.
But in relation to, but was this broader point? It's not. Doesn't seem to have been foreshadowed in the evidence. No one seems to have said, "Look, there's this broad concept of this being important as a matter of US public policy, and on that ground, the document should be withheld." It all seemed to be about, look, we, Standard Chartered, are at risk of some horrible consequence. You're no longer asserting that.
Well, I am asserting that in relation to the USR.
I know, but in relation to the other lot, the broader
yes.
CSI.
I accept that. And I think I accept that the focus of the evidence, the focus of the application below was on the risk of prosecution. I accept that. But the freestanding point of comity was pursued as a legal point on the basis of the evidence that had been adduced from it.
It wasn't flagged up in the evidence. It's not something that the claimants addressed separately in evidence.
That's a fair point, yeah.
Right. So just coming back to Batcher, we did paragraphs 47, 48.
Yeah. I think, rather than take time on it now, the only point I was going to make in terms of the remaining points is that when it came to then applying it to the facts, the court came to the conclusion that the property identified in the request should be disclosed on the basis essentially that it wasn't confidential anymore, it had been frozen, and so all that was required was to establish whether or not it was identified in the request or not, because that was a precondition of the court's jurisdiction. But in relation to the question of whether or not it was relevant property, disclosure was refused, so a redacted version of the request was required to be produced if the...
And that's 56.3, is it, really?
Yes, 56, yes, and as a whole, is the point that Lord Justice Cross makes, that in the substance of this case, the maintaining confidentiality over material in the request that goes to the question of whether it was relevant property.
And is that really an application of the principle we saw in paragraph 31?
It is an application of that principle, yes. Yeah. With the balancing coming down in favour of refusing disclosure. So
refusing inspection.
Sorry. Yes, I'm being loose.
Where is it?
Well, I mean, we're talking about inspection. I in this case as well.
Yes, that's
so it's I'm using disclosure loosely. We're talking about inspection.
Are we? Sorry. I thought this was partly an application to withhold disclosure
Well, I think
itself, so they wouldn't be, so the documents wouldn't be listed.
Yes, that's right. We haven't produced a list, so yes, you're right.
So is this both disclosure and inspection?
It's disclosure and inspection. You're correct. Yes.
And if you were applying the principles in paragraph 31, that would be no basis for refusing listing.
I think that would be right. I mean, clearly there are differences where in the balancing exercise between disclosure, properly so called, and inspection. Yeah.
So what principle applies in relation to listing? That's not what we see in paragraph 31.
No, I think in principle one could imagine a case where confidentiality alone could justify not disclosing even the existence of a document, but it would
Is
be
there what basis for that? For that, is there an English law?
I think there are. I think that I haven't got the older authority to hand. So I think there's a.
I think Nassay.
Yeah.
I think Nassay says that the House of Lords deal with both. Although it was an inspection point, I think they say we're going to deal with both disclosure and inspection, or what used to be called discovery and inspection together.
Yes. I think,
but nonetheless, different considerations may apply at the two stages.
I accept that. I think it's I put it this way, that broadly speaking, it's the same analytical framework, that applies, but the weight that we're given to the different factors or the balance you might draw might be different in the two situations.
I follow. So just we're leaving a batcher, are we? So what do we get out of a batcher? I mean, it's an application of the principles we see in paragraph 31 on the particular facts. What else do we get out of it?
Well, the principle in paragraph 31, and we say that it is also a recognition, albeit in the context of my Lord Justice Miles pointed out, in the context of a treaty obligation in the United Kingdom, but it's a context where of what one would call foreign or at least non-domestic confidentiality being given effect because of considerations of comity.
Just before you leave that case, in that case, I think you said, the NCA was effectively acting on behalf of the American authorities in that case. So the court was effectively hearing from the party affected and
Yes.
claiming confidentiality. In this case, there's no intervention by the US regulators. What are we to make of that?
I would submit not a great deal, in the sense that one would not necessarily expect US regulators to intervene in private litigation abroad. What one does have, at least as regards the Fed and the DFS, are their reasoned decisions in accordance with the US regulatory framework as to what consent they are willing to give for disclosure of CSI in this litigation. And as I'll come on to later, they accept that internal SC documents that refer to or contain CSI can be produced, but have drawn the line at external communications, including direct supervisory communications, which
If
they
they
say,
thought it was really important, they could have come and intervened. Is that right? If they thought this was a really important point of public policy in the US, could they have taken part in this?
in principle, I'm sure they could have sought to have got involved.
Could they have stated their position to be communicated to the English court?
Yes, I accept that they could have done. I mean, I would submit that the latter.
Then the judge might have something to go on.
Well, the judge, in fairness, the position of the US regulators, the DFS and the Fed, is stated in those two letters, which were written on the basis that they would be produced to the court, explaining what their position was. So the regulators would be proceeding on the basis that Standard Chartered will be putting their position, the US regulators' position, before the court in evidence and in submissions. I mean, that's as far as I can take the point. They could have taken further steps. I said that. Moving on, if I may, then from a batcher to Bank Mellat. This was 3 years after a batcher. The judgment of the court was given again by Lord Justice Gross. As your lordships probably know, this was a case involving claims brought by an Iranian bank, part owned by the Iranian state against the UK government under the Human Rights Act, for loss that they had allegedly suffered as a result of a financial restrictions order that had been held by the Supreme Court to be unlawful. And the issue concerned the disclosure of confidential banking data relating to the bank's customers that would have involved the breach of Iranian law. That data was of obvious importance to the quantification of the bank's damages claim for loss of business. But the issue was whether in those circumstances the bank could disclose documents with customer identities redacted and represented by ciphers, or whether the document should be disclosed in unredacted form into a confidentiality ring, and then also in cipher form, with a master list of cipher codes being made available only to members of the confidentiality club. If we could start, my lord, it's tab 6 of the authorities bundle, page 91.
Is this case reported in the official report?
Extraordinarily no.
That's remarkable, isn't it?
I'm staggered every time I go to it, but it's not been reported, given how many times it's referenced, but it is not reported. And then on page 92, one sees the introduction, paragraphs 1 to 3, from Lord Justice Gross. He makes the point that a tension can arise between the English law requirement for inspection of documents, so this was about inspection, and the provisions of foreign law in the home country of the litigant. Where such a tension arises, it's for the court to balance the conflicting considerations, that being the constraints of foreign law on the one hand and the need for the documents in question to ensure a fair disposal of the actions. He then makes a point which is relevant, of course, in this case, about how the balance is to be struck at first instance and the circumstances in which the appeal court will interfere. And then if we could move on in the judgment to paragraph 54 at page 105. One sees there the description of the case as being concerned with what Lord Justice Gross calls a species of confidentiality, namely where a party to litigation in England asserts a right or duty to withhold documents because of a failure to do so would give rise to a contravention of foreign criminal law. And we do emphasise the words a species of confidentiality because it does bring out that what these cases are all about is about confidentiality. And the cases involving breach of foreign criminal laws and a risk of prosecution are simply, in our submission, a subset of the cases involving confidentiality. And one sees that, my lord, if one goes over the page to 106, because at paragraph 55, Lord Justice Gross starts his analysis in this section with a reference to his previous judgment in Abacha. So this is an offshoot of the Abacha line of authority in our submission. Then at 56 to 62, one sees an analysis of a series of decisions which are directly concerned, more or less, with greater degree, as you go through it, more and more on point in relation to disclosure or inspection in breach of foreign criminal laws. And then that culminates at paragraph 63 with the page 109, with the pulling the threads together for present purposes. And emphasise again for present purposes. So he's pulling together the threads in the context of reliance on a foreign criminal law and risk of prosecution. And your logic, I'm sure, will be familiar with these statements of principle, but the court has a discretion to make an order that would or might entail a breach of foreign law. We accept that. But we do emphasise that such an order will not be lightly made, not least with considerations of comity in mind. So Lord Justice Gross has the point about comity in mind as well. And the court can take into account the real, in the sense of actual risk of prosecution. But risk of prosecution is not determinative. It must be balanced against the importance of the fair disposal of the proceedings of those documents. But it is, that being the risk of prosecution, a factor of which the court is very mindful. So that's the framework, as it were, in terms of the legal framework of the court decision of this court as to how the application should be decided. If I can move to make some...
Lord Justice Gross doesn't seem there to... He seems to focus in on the risk of prosecution.
Yes.
He doesn't seem to say, oh, well, even if there's no risk of prosecution, this court should somehow give effect to the foreign confidentiality law.
Yeah, well, we say, at least in this passage, we say that's a product of the way that the case is being put, that it's being put on the basis of breach of a foreign criminal law, and there's a risk of prosecution. The reference to a real risk of prosecution, as I'll come on to in a moment, in our submission is revealing that the real risk is a low threshold. A real risk is something more than merely fanciful, and the reason why the court in short will only take account of a real risk is because if it's not real in that sense, there's not really anything to take into account at all. So what the judge is saying, the no judge Lord Justice Gross is saying in our submission is that one takes into account the broad framework of foreign laws. One can also take into account that where there is a risk of prosecution that is real, that is another factor that can be taken into account. He's not saying in our submission that unless you have a risk of prosecution that is real, one ignores entirely the fact that these documents are confidential under a foreign legal regime.
Is he really dealing with that situation at all? I mean, as you say, he's focusing on breach of the foreign criminal law. Where do you find in this anything really dealing with a different situation?
Well, I agree. It's a narrow decision, and that's really my point. It's not exhaustive of the considerations that the English court takes into account in this area. I mean, I would refer your lordships when it comes to paragraphs 88 to 89 of this judgment, which comes to where in a section where Lord Justice Gross is dealing with striking the right balance. So he's already dealt with the challenge to the judge's assessment on risk of prosecution. He's already dealt with the evidence in relation to the importance of documents. And then at 88 to 89, he does put the matter, I would submit, somewhat more broadly, in that he, towards the end of 88, makes the point that my conclusion isn't reached lightly. It takes comity very much into account. It neither intends nor entails disrespect for the relevant principles of Iranian law, and it reiterates a suggestion about a confidentiality ring as to mitigating possible areas of concern. And then 89, he makes the point about that it's necessary to be mindful of the bank's concern that compliance with this order will involve the commission of a criminal offence in Iran. Comity requires no less. So in our submission, it seems that in these passages, the judge is going slightly beyond simply the sort of binary: is there a real risk of prosecution, is there not? And it's talking more broadly about situations of breaches of foreign laws and what comity requires to be taken into account. But
I mean, I'm just looking at paragraph 42 as you're saying that, and his description of the Iranian law, and he says that the principle of the customer's information won't be disclosed is a constitutional principle under the Constitution of Iran. This is a summary of the foreign law, but that doesn't seem to be disputed. So here you've got something which is actually part of the constitution of the country. Would that not be regarded as a matter of public policy of the state of Iran?
it might be, my lord, but I would draw attention to what is said later on in paragraph 42, which is that the Iranian courts have a power to override it on application, which is actually quite a significant distinguishing feature between, to the extent that one compares the facts of these cases with our case on the US SAR documents. So it's clearly not an unqualified right to confidentiality because the Iranian courts can override it. And one of the points that Lord Justice Gross makes later in his judgment is, well, you, Bank Malak, could have applied to the Iranian courts to get an order to permit the disclosure of this material. You haven't done so. And actually, in circumstances where you an Iranian bank, part owned by the Iranian state, suing the British government for very large sums of money, that it would plainly be in the interest of the Iranian state for that permission to be given if it's a condition of you pursuing the action. So one sees that sort of line of reasoning at paragraph 90, Roman 1. But I accept your lordship's point. There is no direct consideration of the broader comity point that I've taken some time debating your lordship this morning.
But he's dealing there with again the risk of prosecution in that paragraph 90, isn't he? So this is a point about whether there's a risk of prosecution or not.
He is.
What I'm interested in at the moment is that when he set out Iranian law, which says it's a constitutional principle, I accept that he says it's qualified in the way he said. But then when he comes to the principles, it's all about whether there's a risk of prosecution, essentially. And I accept your point, that might go beyond criminal prosecution to action, but that's a different point. But he doesn't say this court should give significant weight to the general public policy of the Iranian, that backs up the Iranian law, which seems to be really your submission.
Well, only in relation to the CSI documents, but he doesn't put it in those terms. I accept in that paragraphs 88 to 89, he does seem to be talking in terms more generally about comity requiring consideration to be given to the fact that it would be contrary to Iranian law. And in the earlier paragraphs of the judgment, at paragraphs 2 and 3, talks in general terms about balancing the tension between the constraints of a foreign law in broader terms than simply just a risk of prosecution. But ultimately, we respect it. it may be a product of the way that the case was argued, in the sense that one looks at a batcher which makes clear that confidentiality alone can, in principle, be relevant, at least in that international sphere context. But also, one sees the general statement principle that confidentiality is a factor that comes into the mix. And we submit that if you accept that confidentiality alone is a relevant consideration, then it cannot be right that one can't bring into the court's consideration of what weight to give to that confidentiality consideration evidence that goes to the underlying public policy and public interest considerations that would be relevant in our submission if that were an English confidentiality obligation.
But one could see that this goes back to something that Lord Justice Snowden was asking. One can see that one can have evidence about the risk of adverse consequences. And it's right to bear in mind that it's the adverse consequences from breaching a foreign confidentiality law. I mean, the laws in all of these cases are about confidentiality, so it's not surprising that he talks about confidentiality. But you can see that you can have hard evidence about that. How likely is it that the litigant will suffer some adverse consequence if the documents are disclosed? What there's no discussion of here is some free-floating or free-standing idea of some sort of prejudice to the state of Iran or the public interest or anything of that kind. I mean, it seems to be the focus of your submission on the CSI document.
Yes, my lord. I accept that isn't the focus of these decisions. But I would say this, that I made this point, I think, in response to a question from my Lord Justice Snowden earlier. But regulation occurs generally on a national basis. So local branches are regulated by a local national regulator. So such that in international litigation there is potentially a disjunct between which regulator is regulating that entity in the public interest and imposing the confidentiality obligations, and the place where the litigation is going to happen. And that could be in England with foreign regulators, it could be in the US with English regulators. It doesn't really matter for the essential point. But those underlying public interest considerations that support the confidentiality of the documents can be evidenced. And where those public interest considerations chime with public interest considerations that underpin similar obligations that exist under the UK regulatory regime, we submit it would be extraordinary if the English court could not take that into account when deciding whether or not those documents should be disclosed. Because otherwise you get...
I think we're going to need to let you move on. Otherwise, so those are the authorities.
Yeah.
We're going to take just the SAR document.
Just before we do move on, though, just can I say in paragraph 63(3) of this authority, there is a reference to Dicey, Morris and Collins. That's to the 15th edition of Dicey, Morris and Collins, which is obviously quite different from the current 16th edition of Dicey, Morris and Collins, because I've just got the 16th edition on screen and that reference doesn't fit. Has anybody tracked down that reference?
I confess I have not followed up that reference.
Simply because it does perhaps answer my Lord Justice Miles's, and say won't necessarily answer, but at least seems to be relevant to it, because it seems to be talking about it's something to do with comity and breach of the criminal law rather than the more general free-floating comity sort of proposition you're putting forward.
If it would assist, we can certainly follow up if we can find the relevant part of the 15th edition provided to the Lordships.
I mean, it's probably best to find part of the current edition, the equivalent part of the current edition.
Or the equivalent, yes.
Yes.
We might do some archaeology and then work.
Yes.
Yeah, I mean, it's quite difficult to pin down as to which paragraph is where, and I think the book did undergo quite a change.
we will do some investigation to work out where the relevant passage, if it still exists, can now be found.
So you're going to take us to the SAR documents?
I am going to go to the SAR documents. So what I propose to do first is deal with the judge's approach to risk of prosecution, so we can move away from comity. Then deal with the judge's approach to assessing relevance, or we say more accurately, the importance to the fair disposal of the proceedings. And finally say something about the judge's approach to the balancing exercise. In relation to risk of prosecution, we say at the outset that a judge may free discrete errors of law in relation to his assessment of the risk of prosecution or other sanction. First, we say that the judge applied too high a threshold as to what was a real risk of prosecution. Rather than asking whether the risk was more than merely fanciful, the judge asked himself whether it was likely or even more likely than not. So that's the first error. The second error we submit is the judge also appears, at least to all intents and purposes, to have treated it as determinative in relation to the USR documents, that Standard Chartered could not point to examples of criminal prosecutions in directly comparable circumstances. So that's to say, in cases of unauthorised disclosure pursuant to a foreign court order. And he did not, we submit, as he said he would do earlier in his judgment, consider the evidence that was before him as to the reasons for the absence of the examples. One doesn't see any trace in the judgment of him having given that consideration. And then third, the judge appears to proceed on the basis that if he wasn't satisfied that disclosure should be dispensed with due to a real risk of criminal prosecution, then it would follow, say perhaps exceptionally, that he couldn't be so satisfied on the basis of non-criminal sanctions. And we submit that was, with respect, an oversimplification of the position. It appears from my learned friend skeleton, which is paragraph 11, we don't need to turn it up, but there may not now be much disagreement between us on the law, as opposed to perhaps the judge's application of it in the circumstances of this case.
Sorry, could you just, I'm so sorry, could you just give me that third point again?
Yes. What we submit that the judge appears to proceed in his judgment on the basis that if he wasn't satisfied that disclosure should be dispensed with due to a real risk of criminal prosecution, then it would follow, say perhaps exceptionally, that he could not be so satisfied on the basis of non-criminal sanctions. So effectively, he introduced a hierarchy of sanctions and basically said, well, if criminal prosecution comes first, if I'm not satisfied about that, then you're not going to satisfy me for other risks. And we say that's I'll explain why in a moment, but we say that's just a far too simplistic approach, that binary approach of setting them up in a hierarchy. Taking those points in turn, if I could take your lordships first of all in relation to the threshold test, more likely than not point. If we turn up the judgments, it's core bundle tab 6, page 97. And it's the first sentence of this paragraph, which, as your lordships will see, is in the beginning of the section dealing with risk of prosecution and or civil enforcement. And he says, so turning to risk of prosecution, if we recall from my survey of the authorities that we're looking here for a real risk of prosecution, namely whether it's likely or not, or maybe more probable than not. We submit that first sentence is an error of law. Indeed, we don't understand the claimants to dispute that would be an error of law if that was the approach the judge took. The threshold we submit...
Just pausing there, what do you interpret that as meaning?
The second part appears to be setting up a balanced probabilities test.
And what if it's maybe the second part, what does the first part mean?
Whether it is likely. Likely means in the context of this sentence, likely means something less than more likely than not. But we would submit certainly something more than purely theoretical, hypothetical, illusory, or fanciful. Likely is obviously a variable scale,
yes.
But it's certainly not something more than fanciful.
Yeah.
The threshold, as I said when we were going through bank balance, is essentially whether the evidence establishes any actual risk of prosecution at all. So the words, as I said, the epithets are illusory, theoretical, hypothetical, fanciful, are the ones used in the cases. So it is a low threshold. The claimants suggest that we have embarked on what they call an unfair and selective reading of individual phrases in a lengthy oral judgment. The first point, just to pick up on the oral judgment point, is that it's correct that the judge delivered this judgment orally on Monday, the 4th of August. But the judge had reserved his judgment and taken time to prepare it in advance of the hearing, having heard oral arguments on Wednesday and Thursday the previous week. And we submit that in that context, the sentence that I've shown your lordships in the judgment at 75 can't fairly be characterised as a slip of the tongue or a light that sometimes you get in an extemporary judgment, if that's the impression the claimants are intending to give. It is the opening sentence of the section of the judgment in which the learned judge sought to assess the evidence on risk of prosecution, and one has to take it as saying what it says. The claimants have referred to a number of other paragraphs earlier in the judgment, which they say suggest that the judge did have the right test in mind. If I could just deal with those quickly. The first two are paragraphs 2.1 and 11.3 of the judgment. So page 65, which simply summarises the basis of the application and uses the phrase real risk of criminal prosecution. And then similarly at 11.3, page 69, uses the phrase real risk of criminal prosecution. All those paragraphs show, my lord, is that the judge used the formula real risk of prosecution. They don't show that the judge correctly directed himself as to what the phrase real risk meant. So that those paragraphs don't exist. Paragraphs 22 to 23 are the next paragraphs my own friends rely upon. Page 75 to 76. And what one sees there, my lords, are a quote from Matthews and Malik and then a quotation from Bank Mellat. In our submission, there's nothing here that shows that the judge himself appreciated that the threshold of real risk be crossed just as long as the degree of risk can be shown to be more than illusory or theoretical. The only references one could see, perhaps, are the final sentence of the Matthews and Malik passage, that in which it said that more often than not, the court will conclude that the threat is more illusory than real. But that, in our submission, doesn't state the test as being that anything more than an illusory risk is a real risk. And then one gets to Bank Mellat, and the only relevant part I would submit is paragraph 63, is sub-paragraph 4 from paragraph 63 of Bank Mellat, where Lord Justice Gross sets out that it's a real in the sense of actual risk. And again, my lord, it's a similar point to the one I made on paragraph 2 and paragraph 11. It sets out a formula but doesn't show that the judge correctly appreciated what it meant.
I mean, that subparagraph 4 is very much at the heart of your submission that the correct threshold is a low one, as I understand it.
Yes.
So if the judge did indeed have in mind subparagraph 4, then one would think that he would have adopted the approach you say is the correct one.
Well, if he did indeed have, the way I would put it, my lord, is if he did indeed have in mind paragraph 63.4, he wouldn't have expressed himself in the way that he did at paragraph 75. But the concept of the real in the sense of actual risk has been unpacked a bit in some of the later cases, such as Joshua and Renault, in which it's described as something more than a fanciful risk. And one sees it again in Morris earlier, more than a purely hypothetical risk. In my submission, this quotation en bloc of the relevant passage of Bank Mellat is a very slender basis on which to seek to knock over what is a very clear statement of the approach the judge said he was taking at paragraph 75. I'd respectfully submit, my lord, that the high point of my learned friend's argument comes at paragraph 24. And at paragraph 24, the judge summarised my own friend's submission, by which my own friend had contrasted a real risk with a theoretical risk, and I accept that. But we do say that, with respect, the judge appears to have lost sight of that point. by the time we get to paragraph 75, some 20 pages later in the judgment. And we say simply that the court cannot be confident in those circumstances that the judge applied the correct test when evaluating the evidence. Indeed, as I'll come on to, we submit that if the judge had applied the right test of more than fanciful risk, he couldn't reasonably have concluded that the evidence didn't establish a real risk in that sense in relation to the US SAR documents.
Just thinking about the consequences of that. So suppose we were at the end of the day persuaded the judge had applied the wrong test, or that on some other ground his decision was vulnerable. What would you say we should do about it?
In my submission, it would at that point his decision would stand to be set aside, and that this court ought to exercise its discretion afresh.
So you would say we would exercise the discretion afresh, not send it back.
Yes.
Yeah.
That's all I had to say on the first point of principle. The second point of principle is the significance of the evidence or absence of evidence of actual prosecutions in directly comparable circumstances. For this, if we could turn up the judgment at paragraph 28, it's page 80. Now, it starts on page 79 with a quote from Mrs. Justice Mulder's judgment at NMC, and then on page 80, there's a comment on that. The first sentence, the judge says, there needs to be evidence of prosecutions for it to be shown that there's a real risk of prosecution. Now, before I move on, read on its own, that seems to put evidence of past prosecutions as a precondition of finding a real risk of prosecution. My learned friends rightly point out in their skeleton at paragraph 11.2 that the judge then does put the point, it seems slightly less high, in the next sentence, agreeing instead with my learned friend's submission, but it's what he calls it is a highly pertinent factor. We make 4 points in response to that. First, the judge seems to be saying that this, i.e. the absence of prosecutions, will be a highly pertinent factor irrespective of the explanations put forward. Because the sentence starts, explanations have been offered in this case for the lack of prosecutions, and those will have to be considered in due course. But I agree with Mr. Patel that it's a highly pertinent factor. So the judge has already seems to have decided that this is a highly pertinent factor, irrespective of the explanations. And with respect, we say that isn't a judgment that can be formed in the abstract. Second, as I've just said, the judge also said in the judgment that explanations for the lack of prosecutions have been offered and they'll have to be considered. But as I said earlier, when one comes to his assessment of the evidence in this case, that is not something the judge did. Third, when we do come in a moment to the judge's very brief reasoning in the judgment, the judge does seem to treat the absence of evidence of prosecution in case of disclosure under foreign court orders as essentially determinative of the question. And we submit that that cannot be the law. It sets a threshold that is impossible for a litigant to cross on the first occasion when any issue arises as to whether or not disclosure must be given in breach of the relevant law. And as we will see, that is precisely this case on the evidence. And the final point, the fourth point, is my learned friends also point to the judgment at paragraph 26, starts on page 77 and goes on to page 78, in support of their argument that the judge accepted that the absence of previous prosecutions may not be a significant factor depending on the circumstances. What one sees here, my lords, is a quotation from the judgment of Mrs. Justice Cockrell, as she then was, in Joshua and Renault, in which she disapproves of the passage from Matthews and Malik and accepts that while in many cases the passage may be right, it is not a safe rule. I'm reading here from the beginning of paragraph 78 on page 78 in the quotation. The rule is proof by the party invoking it of a real risk of prosecution, but the past may or may not be a safeguard to future performance or risk, depending on the circumstances. The judge then goes on to consider this part of Mrs. Justice Cockrell's judgment in the text towards the bottom of the page by the second hole punch. And the judge's conclusion was that Mrs. Justice Cockrell was referring to a particular situation where there may have been a change of policy by the foreign state, which makes prosecutions more likely. There's no evidence in this case of any change in policy by the US regulators. Indeed, we have no idea what their policy is. And it's just Cochrane accepted, but in many cases, the passage cited may be right. On the face of it, my lords, this suggests that absent evidence of a recent change in prosecutorial policy, the judge did seem to require there to be evidence of regular enforcement in closely comparable situations. And we say the proof of that comes, as I say, when you look at how the judge dealt with the absence of evidence of prosecutions in directly comparable situations in this particular case. The third point of principle, which I can perhaps take briefly in the light of our discussions about claimants and so on this morning, is we say that the risk of non-criminal sanctions must obviously be relevant to the analysis of whether there is a risk of, to whether or not disclosure should be dispensed with or withheld. And the nature of the extent of that risk needs to be assessed on its own merits, without starting with an assumption that non-criminal sanctions are inherently less important in the analysis. As we discussed a while ago, Bank Mallet was a case dealing with foreign criminal laws and risks of prosecution. It was not concerned with any wider proposition as to whether or not risk of prosecution is criminal prosecution is the only relevant consideration in cases of foreign law confidentiality. And we just say, as a matter of principle, it can't be right that criminal prosecution is the only thing that matters. Other non-criminal sanctions or consequences, such as regulatory enforcement, may be very, very significant for a disclosing party. The penalties, the civil penalties that are imposed on financial institutions for breach of regulatory requirements can be very, very substantial indeed. And the court may well also regard, on the facts of a particular case, that a non-criminal sanction will be more likely than a criminal sanction, even if they do take the view that it might be less serious. And it plainly has to be the case that the court can take an approach of saying, well, I think there is a more likely but less serious consequence of this civil sanction and a less likely but more serious consequence of this criminal sanction, and put those into the balance and weigh them accordingly. The idea that a non-criminal sanction is inherently lower down the scale in the abstract is simply wrong in our submission. It's far too simplistic analysis. And we say that is the approach that the judge took if one looks at the judgment, paragraph 35, page 82.
Why do you say that it's a non-criminal sanction cannot be lower down the scale, or it's too simplistic? I mean, societies generally criminalise conduct that they take particularly seriously and want to discourage people doing. Societies generally do not criminalise things, but impose administrative or regulatory sanctions for things that they find less offensive. I mean, isn't criminal law the way that society marks out what it thinks is particularly important that you shouldn't do? Why isn't there a hierarchy between criminal sanctions and non-criminal sanctions, just as a matter of general policy?
I accept as a general proposition that conduct which is only criminal and conduct which is only capable of attracting civil sanctions, one may say that there is, in that sense, a hierarchy of norms.
I'm just trying to understand. I sort of understood you to be saying that the judge was wrong to create a hierarchy of importance to the reaction of a foreign state to particular conduct. I mean, if you're saying he's not wrong to treat it as a hierarchy, but it would be wrong to ignore anything that wasn't a criminal sanction, that's a different argument.
What I'm saying in terms of my hierarchy point is that what I am saying is that one can imagine cases where the fact of a civil sanction, a serious civil sanction that is which would have serious consequences for a party, may feature more weightily in the court's analysis than a lesser criminal sanction. Just simply because, I mean, in this case, one doesn't. In my lord's point about is there a hierarchy of norms, because criminal laws are generally regarded as stigmatising conduct which is regarded by the state as being more serious. in this case, it is accepted that the disclosure would be both criminal and civil. So the risk is really about the type of sanction that might be imposed. And as we have seen from the Bank Mallet analysis, the focus, at least in that judgment, is on the consequences for the disclosing party. And so one could certainly see, my lord, that the court may take a view, well, I don't think criminal prosecution is very likely, or that if there is a criminal prosecution, there's not going to be a very serious consequence. But actually, I can see that there is a likelihood or a higher likelihood of a civil sanction, and the consequences might be higher, or a combination of the two. And that all has to go into the weighting analysis without starting the position that we say that the judge took in 35, which is that if he's not satisfied by the argument on the basis of risk of prosecution, then taking a step back, he's not going to be satisfied by reference to the much lesser penalty of a civil sanction.
I mean, it's a matter of words. Can you quite object to this, even on your case? So he says, if even where there is a real risk of prosecution proved, the English court will rarely be persuaded to dispense with disclosure. Well, that's a different argument.
Yeah.
He says it must be even more unlikely that it would do so because of a risk of a much lesser penalty, such as a form of civil enforcement. Well, you would accept, presumably, that it's going to be less likely to dispense with disclosure where there's a risk of a much lesser penalty.
I accept that, my lord. I'm with respect, I'm not sure that's quite what well, it's not certainly quite how I interpret what the judge is saying, which is that it seems to be a statement of principle that if he's not satisfied by reference to risk of prosecution, then inherently there is a much lesser penalty of a non-criminal sanction, and therefore that will not cross the bar if he doesn't think it gets over the bar on a real criminal prosecution.
But does it quite say that? It says it's going to be more unlikely if there's a risk of a much lesser penalty.
Well, if the correct interpretation of this passage is that all the judge is saying is if the court finds that the civil sanction is a much lesser penalty than the criminal sanction, and all other things being equal, for example, probabilities and so on, then it would be less likely. I accept that. I mean that's just logic. But in my submission, this passage is actually saying a bit more than that, which is portraying a mindset that the first and only real question is real risk prosecution. If you're not satisfied by that, you can almost just put the rest of it in a box and ignore it, because I'm not going to be persuaded, because it's just inherently much lesser, and I don't even have to look at the probabilities of it. So, but I accept your lordship's point. It depends on how you read the passage.
Yeah.
If I may, if I could just move on now to turn to the evidence on the risk of criminal prosecution and the way that the judge dealt.
Just before you do. Well, you're going to come back to paragraph 41 at some point, are you?
I was going to come back to 41 when
in that case, let's park 41 and come back to it later.
I was going to come back to 41 in the context of the committee arguments, and I may skip over those at this point, given how long we spent on it earlier. But if there's a question your lordship has for me on 41.
And it is the same territory, because he says if you can't show real risk of prosecution, the law isn't going to help you insofar as you're relying on some lesser form of regulatory action or even paying due deference. That can be protected by restrictions by way of confidentiality ring. It's akin to respecting civil obligations of confidence to third parties.
And we say this passage is with respect totally flawed in its reasoning. What first of all, the judge seems to be saying the law is against us if we can't show real risk of prosecution. So he seems to be setting up a legal point that if there's some lesser form of regulatory action, so you get the idea that it's lesser again. Albeit I accept my lord's point that if he's saying on the facts lesser, then it may be unobjectionable. And then he just jumps without having said any of the evidence to saying that the civil sanction point can be addressed with a confidentiality ring. But that surely just depends on the circumstances, my lord. If it comes to the conclusion that there's no risk of a civil sanction because of a confidentiality ring, then that might hold. But it says that as a statement of principle that a risk of non-criminal sanction can always be addressed by a confidentiality ring. That just is illogical, my lord. It doesn't make sense.
Yeah. Sorry, you were going to go on.
I'm going to move on just now to the evidence and the judge's assessment of it. There was only one source of the US law evidence on US SARS from Standard Chartered. It wasn't disputed by the claimants. And it is important I take your lordships to it as briefly as I can, because as your lordships will see when we come to the judgment, you won't get much of this evidence from the judgment. It really is not addressed properly at all. If we could turn in the supplemental bundle to tab 9, and it's page 146. This is a letter from Mr. Himamori Das, now of K2 Integrity, but between 2021 and 2023, he was the acting director of FinCEN, so the regulator with which we're concerned most directly for the purposes of the US SAR documents. As I said, his evidence wasn't disputed, so the only point that the claimants made was that it didn't establish, they said, a real risk of prosecution or other sanction. They accepted that his evidence was correct and challenged it. I would just highlight the following points, my lord. If we turn to page 147, at the top of that page, for the final sentence of the first paragraph, one sees the point that the unauthorised disclosure of US SAR documents would be a violation of US federal law, and such violations may entail civil and or criminal penalties. Well, then in the second paragraph, one gets the point that US SAR documents are also CSI. They in a sense, they straddle the two regulatory regimes. But Mr. Das does also refer to an FRB rule, so the Fed rule in relation to disclosure of SARs, in which the Fed has stated its policy that disclosure of US SAR information in private legal proceedings will not be permitted. So it sets up, even within the context of CSI, it sets US SAR documents or US SAR information on a higher plane with a stated policy in US legislation that if you make a request to disclose this in a private legal proceeding, we're going to say no.
Does that mean if the regulated person says, I want to use the document in legal proceeding, the regulator will say no? Or does it deal with the question of whether a court orders it to produce it in a private legal proceeding?
I'll come on to that, my lord, but I think it's both, because I'll show your lordships that US law is that if a court orders it, then the party in receipt of the court order is required to say no, I'm not going to comply, and refer that back to FinCEN. And then go through or to go back to the FRB and go through the request procedure, and the Fed's stated policy is we're going to say no in relation to CSI. So
in relation to SAR,
in relation to SARS, yes.
It's a specific point about SARS.
It is a specific point, and we do have it in the bundle. I wasn't going to turn it up, but it's tab 12-180, which is the specific Fed rule. It may be worth just going to it quickly, so you, in light of my lord with Snowden's question at 180. So the board policy this is the code of federal regulations, section 261.23, and sub A sets out the board's policy, and sub 1 of A talks about CSI in general terms and explains that there's a balancing between the substantial need and the board's need to maintain confidentiality. But then 2 makes the point that it will not authorise access to suspicious activity reports, including for private legal proceedings, including any requests pursuant to this section.
Yes, but sorry, the thing I was trying to tease out is that there are 2 things that seem to be distinguished in these paragraphs. One is use, and the other one is disclosure.
Yes.
And they seem to be different. Use seems to connote that the person making the request wants to use the document as opposed to being forced to disclose it. Is this dealing with anything more than an entity saying we would like to use the SAR in the private legal proceeding? I'm sorry, I'm just.
I think it is, my lord, because if you it says the board will not authorise access to or disclosure of any suspicious activity reports, and then that's the top beginning of 2, and then refers to official duties. Then, so the purpose of this part, official duties shall not include the disclosure of the SAR or any information that will reveal the existence of the SAR in response to a request for disclosure of non-public information or a request for use in private legal proceedings.
So if a US court orders disclosure of a SAR, this is a defence to that order, or the US courts can't order disclosure of SARs.
Well, they don't, my lord. But as in, I'll show your lordship in the evidence in a minute. But there is a settled practice that this privilege is essentially inviolable. It is the US courts do not order it. But just to complete the point, perhaps in relation to how the Fed regime works, if my lord comes on to page 344, is the next provision of the Code of Federal Regulations in relation to CSI. Page 344 behind tab 17. So this is a position in relation to CSI specifically, and sub 3B makes the point that unless authorised by the board or as ordered by a federal court, in a judicial proceeding in which the board has had the opportunity to appear and oppose discovery, any person is required to respond to a subpoena or other legal process concerning board CSI information or other non-public laws to attend, etc., and refuse to comply essentially. And what this seeks to do, my lord, is unless the Fed has been given the opportunity to be heard in a federal court on the matter, that the responsibility of a party served with an order of the court is to essentially say, no, I'm not going to comply, go back to the Fed and trigger the request process, which arises pursuant to the previous provision of the CFI. But as we'll see from Mr. Dass's report, Mr. Dass's letter, there are further provisions outside the CSI context, which specifically apply to US SARs as well in relation to litigation, and I'll show you, Lordship, the references to that. If we go back, I think, to page 147,
so what is C?
Sorry, I'm lost my notes.
Sorry, you took us to B.
B. So that's a civil request. So I think that would be something like a subpoena, or like.
I don't know, because subpoenas are in B, aren't they?
Yes, I see that, my lord. I'm not sure we have any evidence precisely about what the scope of the civil request provision is as compared with B. Just going back to 147, if I could just run briefly through the remaining points on the evidence. One sees towards the bottom of the page that Mr. Dass identifies various what he calls compelling reasons that underlie the principle of SAR confidentiality. I don't want to labour particularly at this point. But then over the page to 150, under the heading, halfway down the page, is there an exception if a party is required to disclose pursuant to an order from a US court, which addresses the point which we've just been discussing with Snowden. He makes the point that there is no exception in US law for disclosure of US SAR information in litigation pursuant to court orders, and in fact that a financial institution that's in receipt of subpoenas or other litigation-related disclosure requests or disclosure orders are required to decline to produce the SAR and to notify FinCEN. So that's the first little bit of that first paragraph under subheading A. Then the second paragraph, one sees that FinCEN has specifically expressed concerns about disclosure of SARs by counsel in the context of civil litigation, and deals with the point that private parties are seeking SARs from financial institutions. So that this goes to my Lord's point about whether or not it's about where the financial institution wants to use it itself or where it's being faced with disclosure requests. And it's quite clear that FinCEN is concerned by the latter as well. And then over the page, 151, the point is made that the courts in the US generally seek to avoid conflicts with SAR confidentiality rules. And the consequence of that is that they essentially recognise an unqualified discovery and evidentiary privilege and refrain from issuing disclosure orders directing SAR disclosure litigation, even pursuant to protective orders. So that's a protective order is something akin to a confidentiality ring in US litigation. And indeed, that while FinCEN has more recently refrained from intervention litigation in light of the well-settled case law, the US government had in fact previously intervened in cases to affirm the need to maintain SAR confidentiality. Then over the page to 152, I should just refer briefly to the top of the page. Mr. Das identifies a case involving the US Virgin Islands and JP Morgan relating to the Epstein matter, in which, at least with the acquiescence of the regulators, US SARs were allowed into the litigation in circumstances where both parties to the litigation already had copies of the documents. It's not in our submission quite an exceptional case, and indeed the only case that Mr. Das is aware of in which US SAR documents have been released in private litigation. And then at the top of bottom of 152, one sees that Mr. Das says he wouldn't expect FinCEN to ordinarily authorise disclosure of SARs that would reveal the existence for SAR in proceedings in a foreign jurisdiction. And over the page, at the bottom of the first paragraph, one sees that it said that the regulations don't distinguish between domestic courts in the US and courts in foreign jurisdictions. And then at the bottom of page 153, the top of the final paragraph, one sees it said that the US courts have been unwilling to depart from the strict rules of SAR confidentiality, even on the basis of protective orders. So that repeats the point I've just made.
So he's dealing here with what the FinCEN would do if told that a party to English proceedings would be, if the English court had ordered a party to English proceedings to reveal the existence of a SAR or to disclose it. He says, US law tells the party they've got to notify FinCEN of the request. And then I would not expect that FinCEN would ordinarily authorise the disclosure of SARs or information, but it might do.
Well, he's not. I don't think he's identified any example he's aware of in when it's up. But
I mean, the whole code of federal regulations that you took us to at tab 17 just simply say it's all about notification to the board, and the board can do what it deems appropriate in the particular circumstances.
Indeed, but subject to the caveat that there is a stated policy of the board that it won't give consent to disclosure of US SARs in litigation. And I showed your lordship the reference in Mr. Das's letter. The similar provisions relate to the US to getting as regards FinCEN, but there's a notification obligation as regards FinCEN and an obligation not to comply unless and until FinCEN grants consent, which is obviously the order that we sought. If I may, just in the interest of time, could I just take your lordships quickly to 2.3, question 2. Page 154, question and answer 2.3. Mr. Das was there asked what potential sanctions may apply to a party or its employees if unauthorised disclosure is made, and then asked again, in particular, have sanctions been applied to anyone that disclosed SARS or SAR information pursuant to a court order, US or foreign? And this is obviously of particular importance when it comes to looking at what the judge said about risk of prosecution in his judgment. In that context, he identifies the potential for both civil and criminal penalties, as well as, in the footnote 52, supervisory action on the basis of, for example, the inadequacy of financial institution controls. And then he gives on page 1454 through to 155 some examples of past prosecutions. We acknowledge that none of those are directly comparable. But then over the page to 155, the final sentence, which is important, I'm unaware of a circumstance in which a US or foreign court has ordered the disclosure of SARS, or a case in which FinCEN has imposed penalties in a situation where the court has ordered the disclosure of SARS. And that is an important sentence, my lords. As we'll see in a moment, the judge latched onto the final part of that sentence, so i.e. Mr. Das was not aware of FinCEN imposing penalties for disclosure of US SARS under a court order. But he ignored the earlier part of the sentence, which explains why that was the case. That's to say that Mr. Das was not aware of any case where an order for disclosure of US SARS had been made by a US or foreign court. And it obviously follows that if no orders have been made for disclosure of US SARS, then there will have been no prosecutions for disclosure of US SARS pursuant to those orders that have not been made. And in light of what I've shown your lordship, there are cogent reasons why this fact pattern doesn't appear previously to have arisen. And that was plainly in our submission a good reason and explanation for the absence of examples of previous prosecutions. So against that background, if we could turn up the judge's reasoning on this, it is very brief, but starting in the core bundle, page 107, So 107, starting at paragraph 94. Look, at this point, the judge has already dealt with CSI documents and declined our application in relation to, or dismissed our application in relation to those. He then says at 94, you'll be pleased to hear that I can be somewhat quicker with the remaining two categories of documents, as it largely flows from my conclusions on the CSI documents and the defendant being in a somewhat weaker position on those. First, the USR documents. In our submission, that's illogical and wrong to start from the position that because he's dismissed our application in relation to CSI documents, that it largely flows from that decision, that the same result, flows in relation to the US SAR documents. As we've seen, it is correct that the US SARs are CSI, but they're not just CSI. They're subject to a distinct, separate regulatory regime, which has been dealt with in the evidence of Mr. Das, that was uncontested by the claimants. So in our submission, that is not a good starting point for this section of the judgment in our submission. And then when one gets to the risk of prosecution or the analysis of that, it appears it starts at paragraph 99 on the next page. And 99 simply introduces the evidence and explains that the claimants don't dispute it. 100 does acknowledge that unauthorised disclosure is a violation of federal law and criminal and civil penalties may be imposed, and then refers to the 3 cases that have been identified by Mr. Das, which he then says are far removed from this case. And also says the penalties are relatively modest. He does not then deal with any of the rest of the evidence, my lords, that I've shown you over the last 10 or 15 minutes. And the operative paragraph is then 101. which is, on any view, extremely compressed reasoning, given the evidence that was before the court. And with respect, we submit that it is insufficient and inadequate in the circumstances of this case. The first sentence of this paragraph, 101, while Mr. Das spent some time talking about disclosure in US litigation, pausing there, I've taken you through that evidence about US litigation and explained its significance. The judge doesn't even begin to grapple with the significance of the evidence given by Mr. Das in relation to the treatment of US SARs in US litigation, and in particular, that there's no exception for disclosure in litigation or pursuant to court orders under US law, that as a matter of settled practice, US courts don't order disclosure of US SARs precisely because of this strict confidentiality regime, that if a court order were to be made, US law requires a party to refuse to comply with it and to notify FinCEN. And no distinction, Mr. Das says, is drawn in the regime between US and foreign court orders. So none of that context is explained as to...
Well, he's previously recognised that disclosure would be a violation of American law. So now he's focusing on what's the likelihood of a penalty.
I think that must be right. That must be right, my lord. But the point is that all of this evidence about the way in which US SARs are treated in the context of litigation and disclosure is plainly relevant to an evaluation of the risk in circumstances where it's accepted that disclosure would be, absent consent, a breach of the laws that the judge accepted existed and the claimants accepted were applicable, and where the point which the judge is kind of going to make in the second half of this sentence is, well, there aren't any examples of cases in which a prosecution has happened for disclosure pursuant to a foreign court order. And that it's simply the judge doesn't acknowledge in drawing that conclusion in the second half of this paragraph, but it simply flows from the fact that there aren't any cases, at least as far as our expert was aware and his evidence wasn't contested, of cases where disclosure of US SARs has even been ordered in the US or abroad.
Well, what he says in between is what's missing is an assessment of the risk or of prosecution or civil sanction, and that's pretty much fair, isn't it?
I'm going to deal with that point head on. First of all, I was going to deal with it. I was trying to deal with it in stages. But first of all, that's my criticism of the first sentence. That he's really not begun to contextualise the significance or otherwise of the absence of prosecutions in directly comparable cases of disclosure pursuant to foreign court orders in the light of the evidence as a whole. None of that context appears in the judgment. And we say, contrary to the way in which the evidence was presented, it doesn't support that first sentence, an inference that there was no real risk of prosecution for admitted breaches of these US laws.
I mean, whatever it may or may not support by inference, it's correct.
Sorry?
The sentence is factually correct.
It's correct factually, but shorn of so much context as to be somewhat misleading, I would suggest, my lord. And then, as my lord has rightly pointed out, the judge then criticises Mr. Das's evidence for not including any assessment of the likelihood of prosecution directly, and suggests that it's significant that he wasn't asked the question. In our submission, strictly speaking, the assessment of the level of risk of prosecution is not likely, at least to a large extent, to be the proper subject of expert evidence at all, in the sense that foreign law expert evidence should be confined to foreign law or possibly foreign practice, the meaning and effect of provisions and so on and the like. And the evaluation of whether there is a real risk of prosecution is essentially a factual question to be drawn in light of that evidence as to what the foreign law evidence, what the foreign law is, and that is a point we submit that is made, albeit going the other way, in the circumstance of that case, in Bank Mellat, paragraph 70.
Just thinking around that. So Mr. Das does say, well, FinCEN investigates each allegation of improper disclosure and may take action against those responsible based on factors such as the gravity of the violation. Well, I suppose that's common sense. But if an expert can't go further, as you're saying he can't, don't you have to sort of think, well, is it inherently likely that the American regulator is going to take action in the context of compliance with an English court order in relation to a small number of documents?
Yes, I mean that comes back to the point of the weight that the English court gives to the fact that it's making the order, and in a sense, as in comity terms, the English court order is entitled to respect abroad, and so that would influence prosecutors. And plainly, I mean that's a relevant consideration, albeit it becomes a slightly circular, self-fulfilling analysis at times, because if shorn of any other context, it simply becomes, well, if I make this order, I can take away any risk of prosecution that exists, rather than actually evaluating the general public interests considerations.
Can we separate the two a moment? If I'm concerned with the risk of prosecution, which is what seemingly we're focusing on here, you do have to think about whether, in circumstances where an order has been made and FinCEN is evaluating the gravity of the violation, is going to think there's something that we need to do something about.
Yes, I mean, I accept that the context in which the court is making its assessment of the real risk of prosecution becomes one in which the order has been made, because one is asking whether there's a real risk of prosecution for having complied with the English court order.
You might, sorry, just to add to that formulation, you might say also in circumstances where the regulated entity has done everything it can to uphold the confidentiality by opposing the order of the court, but the court in the teeth of that nonetheless said hand it over.
Well, I accept that. In a sense, one can only that is a relevant consideration, and the authorities, Bank Mallat says it's a relevant consideration. So I don't shy away from that. But there is a limit to how far one can take it, in the sense that the basis of the respect for the English court considers will be afforded to its orders is comity.
Well, actually, that isn't right here, is it? It isn't a question of comity, it's a question of risk. The American court isn't going, the American regulator isn't necessarily going to say, we're not going to prosecute as a matter of comity. They're going to say, we're not going to prosecute because we understand why you did what you did, which is the English order.
Yes, I mean factually that's correct. The reason why I say it's about comity is in Bank Mallat, Lord Justice Gross prefaces his point with his phrase "comity cuts both ways," and it's treated in the case as being an aspect of comity that if the English court has made an order after due consideration, that the foreign authority, albeit not a court, but the foreign prosecutor will give it due respect, and that's been given a sort of shorthand notion of comity. But I accept your lordship's point. But
sorry, can I, at the risk of catching up, as I read the evidence, what the evidence that you showed us said is, if in the States you are a regulated person and get served with a subpoena or some other document that would require you to disclose in civil litigation as SAR, you have to tell FinCEN and don't disclose it until you've done so.
And not disclose it unless they say you can.
Correct. And then it also goes on to say that the US courts have in those circumstances themselves not made orders for disclosure, but have given priority to what they call the non-waivable unqualified discovery and evidentiary privilege for such information.
Yes. So
the US court US courts stepped back as a matter of US policy.
Yes.
So the regulator has never actually had to deal with a question where a US court had ordered, and we know it's never had to deal with a situation where a foreign court has ordered. Why should a foreign court, in deciding whether in the exercise of its own its own jurisdiction and its own policy, be assumed to follow the lead of the American courts, and why should it be assumed that the foreign regulator would say, if a foreign court did make such an order, oh my goodness, we will prosecute you anyway for complying with a foreign order. I just don't see this evidence going far enough.
Well, I mean, there are two aspects to that, my lord. One is the real risk of prosecution question. One is should the English court come to the same answer as the US court out of respect for the way that the US do it. We submit there is a comity point there, but about the settled practice in the United States, the deference that the US courts show to the policy rationale and the legal restrictions on confidentiality of USRs is informative when it comes to considering whether, even independently of risk of prosecution, there is a comity public interest point to be taken into account in relation to this confidentiality regime. But
but the US court exercises its discretion as a matter of US law and policy.
it does.
It's not necessarily the same as the discretion that we exercise.
No, and I'm not saying it is. All I'm saying is that it.
Do we have details as to why the US court has given way in this circumstance?
Not beyond the way it's described in Mr. Dass's evidence in terms of the acceptance that the US legal regime sets up effectively an unqualified privilege and effectively in complete deference to FinCEN and its judgment as to whether or not there should be disclosure of USR.
But that's just stating the result, not the reason.
Well, I think the part of the reason must come back to the rationale given at the beginning on the first page of Mr. Dass's or second page of Mr. Dass's letter about the rationale underlying USR confidentiality. If I may, in relation to the effect of an English court order on the risk of prosecution, I do say that there is a distinction to be drawn in this case where we know that the US courts do not make orders of this type, and there is no exception for US litigation. And there is the court. This court, I think, in our submission, should be more cautious about assuming that a US regulator faced with an English court order that it would never receive out of its home courts is going to be quite as accommodating as it might be otherwise out of respect for the judicial process in this country. So that's just on the factual point about risk of prosecution. Going back to the criticism of Mr. Dass's evidence about not opining on the risk of prosecution, what Mr. Dass has done is he's been asked what potential sanctions may apply and what sanctions have in fact been applied for disclosure pursuant to court orders. And as I've already shown your lordships, Mr. Dass answered those questions to the extent that it was possible for him to do so within the confines of A, what is appropriate for an expert giving evidence of foreign law, and B, as to what material there was for him to answer those questions. There is a big unknown here, which is that it's never happened before. But
he doesn't even go as far as to say, I think, in my opinion, there is a real risk. He just doesn't.
Well, he doesn't. He doesn't say it in terms there's a real risk, but in a sense
he doesn't say it at all, does he?
Well,
he doesn't even answer. I mean, the judge is right, isn't he? That he's not been asked that question.
Well, he's not been asked that question, but I would submit that in a sense it's not exactly the right question for him to be asked or to answer in his capacity as a foreign law expert in this case in circumstances where it's never happened before.
And there's no evidence at all before the court. So what is it? Something the court's just supposed to somehow take a view on?
It's essentially an inference as to whether one crosses the real risk, non-fanciful risk threshold. But in circumstances where, unlike many other cases, it's acknowledged that this disclosure would be in breach of the US law. It's acknowledged that there's no exception. It's acknowledged that it never gets ordered in the US. And it's acknowledged that the expectation of the US is that if you get faced with a court order from a US court, you should say no. So these are all facts on which the court can build an inference that faced with a situation where a foreign court order does what a US court would never do, that the US regulators stroke prosecutors may take a dimmer view of it than the English court might hope they would. and we submit in circumstances where there is no directly comparable precedent on which to draw, that essentially to ask Mr. Das to say, well, what do you really think? Do you think there's a real risk here of a prosecution? And he's bound to say, well, I don't really know. It's never happened before. I can give you some indication of the sort of considerations the regulators might take into account, but I can't really go much further than that.
Just one follow-up. You say, well, the judge applied the wrong test and whatever. Suppose he didn't apply the wrong test, and here we see in 101 his application of hypothetically the right test, and he arrives at a conclusion. Would we be entitled to interfere with his conclusion?
I mean, we say yes, because we do say that independently of the legal errors that I've identified at the outset, that the way in which the judge dealt with the evidence, starting off with his starting position, that in a sense his decision flows from what he's decided about a different legal regime, about a different category of documents on the basis of different evidence, should somehow affect this, followed by his, in our submission, insufficient reasoning and engagement with the underlying evidence, that is sufficient to justify your lordship's interfering with
But
this.
is this, this must be either factual or evaluative. This court doesn't normally rush to interfere with factual or evaluative conclusions by first instance judges. In the context of factual conclusions, Lord Justice Lewison has spoken of rationally insupportable. I mean, is it that sort of test that you have to satisfy?
I think yes. If there's no legal error, then yes, it is that standard test for interfering with factual findings or evaluative judgments. But we do say that there is a logical problem here. A would basically saying, because I've dealt with it under CSI, it's basically already been dealt with, and I can take it very briefly.
Yeah.
And then B, the failure really to engage with any of the underlying evidence or to include any substantive reasoning as to why it doesn't lead to a risk of prosecution. In circumstances where the first sentence we submit is so compressed to be misleading if one reads it in isolation as to what the evidence actually did say for him. So we do say that on that basis you would be entitled to interfere. If I may, I think I maybe lost the time on the CSI documents, but we have covered the comity point at quite a lot of depth. If I could just deal briefly with the importance of the USR documents, the fair disposal of the proceedings, which is the other side of the balance, as it were. The first point my learned friends make is that the claim that the judge, as the designated judge for this litigation, was uniquely well placed to evaluate the potential relevance or probative value of the documents. And as a basic proposition, one can see that carries some force. What we would say, though, is that that point obviously presupposes that the judge did carry out a critical assessment of the evidence before him as to the probative value of the documents in the light of his acquired knowledge of the case. And we say that one doesn't get any hint of that in the way in which the judge dealt with that in the short section of his judgment dealing with the importance or relevance of the USR documents. In particular, we say the judge didn't meaningfully engage at all with whether the documents were not just relevant, i.e. disclosable, but likely to be important for the fair disposal of the proceedings, which is the relevant test under Bank Mellat. With respect, we submit that the judge's analysis didn't really get beyond noting that the documents had been identified by Standard Chartered's legal team as relevant and thus crossing the threshold for disclosure. But as all litigators know, there are hugely varying degrees of relevance of documents beyond that threshold. And the fact that a document may be disclosable doesn't mean it's likely to be important for the fair disposal of the claim. In particular, we would draw your lordship's attention, I perhaps won't turn them up in the interest of time, but to judgment paragraph 52, the final sentence, judgment paragraph 66, the final two sentences, and judgment 106, the whole thing. And we say those passages are illustrative of the judge's mindset that for this stage of the analysis, it was enough that the documents had been categorised as disclosable. But as you'll appreciate, that will be the case, essentially, in any case where this issue arises, because if they're not disclosable, then no issue about withholding disclosure ever arises. So the test must mean something more than that.
Very often in these cases, the judge is able to look at the documents. So, for example, in the Nassau case, which was possibly the leading case on confidentiality, the House of Lords said that normally the court should look at the documents. And how does it work in a case where one can't look at the documents and where there's very little evidence about what they contain?
I mean, that is the difficulty of these cases. What we submit the court ought to do is consider, on the basis of all the evidence and the understanding of the issues of the case, how important the documents are likely to be in their own right, and the likelihood of other evidence going to the same matters being available from other sources, so as to reduce the importance of the documents sought to be withheld. And in this case, as your lordships will have seen, Standard Chartered did produce evidence explaining its legal team's assessment of the likely importance of the documents in question. And that evidence, of course, was constrained by the very same restrictions that apply to disclosure and inspection, but went as far as we considered we were able on advice to go. But we are not aware of any previous case in this area in which the lawyers for the disclosing party had adduced any evidence explaining, so far as they were able to do so, why the documents in question were unlikely to be important to the fair disposal of the proceedings. And our assessment in relation to the USR documents is that they are likely to be of limited probative value. The evidence on that is in Lewis 21, paragraphs 47 to 49, supplemental bundle 8, pages 130 to 131. The judge rightly accepted his judgment that this reflected a genuine assessment of Standard Chartered's legal team. We obviously accept that to some extent it involves a value judgment. But on one level, it's not in principle different from the judgment that parties' lawyers are expected to make in relation to disclosure generally about whether or not a document crosses the threshold at all. So it's not an exercise that's different in kind from that exercise. Obviously, there are documents on one stream which are obviously relevant, some which are obviously irrelevant. But when you get closer to the line, there are judgment calls to be made, and that's just a standard feature of litigation. So this is a professional judgment by experienced lawyers with a good understanding of the issues in the case, explaining that they think that these documents are of limited probative value. And that is a significant consideration. The other considerations in our submission are these. First, that it's a very small number of documents. So 16 unique USR documents, 43 documents in total, of which 4 are actual USRs, if I can put it that way. And the remaining documents are ones which refer to the existence or content of SARS amongst other material. And those documents, with 1 or 2 exceptions that relate to CSI at this stage, have been disclosed already with redactions removing the USR information. So those documents are already in play. We do say that a small number of documents involved is a relevant factor when one comes to consider whether the documents are likely to be important for a fair trial, when seen in the context of both the size and composition of Standard Chartered disclosure as a whole. By contrast, one sees in many of these cases that what's being suggested is there should be a withholding or disclosure of vast numbers of documents which are obviously of central importance. That's not this case. I would also emphasise, just on this, the following 4 points, and I probably then will run out of time. But first of all, there is no US law restriction on the disclosure of any internal documents concerning the matters that led to the USRs being made. So, for example, documents relating to the transactions themselves, the customers, and so on, those are disclosable. What is not disclosable, or what is not permitted to be disclosed, if it's more accurate, under the regulations in the US, are evidence which goes to the existence and content of the US SARs themselves.
But, I mean, SARs are usually really significant because they're normally prepared by compliance and other teams within inside a financial institution. who have looked at all the underlying documents have the ability to speak to the people involved and pull it together in a report to the regulators because there is suspicious activity going on. So is it really an answer to say, oh, well, the SARs aren't that significant because the other side in litigation will have all the underlying documents but none of the ability to draw it together in the same way as the internal teams of banks do?
I accept. There may be some additive value of the documents themselves.
Quite a lot of added value, isn't it? Isn't that the whole point of having compliance departments and people who produce SARs? I mean, they are, you know, a carefully assembled, following it usually investigation within the institution, statement of what the position is.
Okay. I accept. I accept that that those documents may show an evaluation of underlying evidence, but of itself may obviously. I haven't the detail of the individual.
I was just querying. Your answer seemed to be, oh, they shouldn't worry their little heads about getting a SAR because they'll get all the other underlying all the underlying documents that the people producing the SAR would have looked at. So what's the difference? And I'm saying
yes.
there could be quite a lot of difference.
That's my first point. The second point about other available material, my lord, is that subject to CSI and privilege, there is no restriction on the disclosure of the large volume of other material generating the investigations about conduct that led to the 2019 settlement. And so what we're talking about here are literally just the SARs. So that all the wealth of other analysis is not subject to the same restriction. So that's plainly going to be relevant to what other material will be available. And I've also mentioned the fact that the affected documents have been disclosed with the redactions of the USR information. So that information is already out. So we're not suggesting that because there is a document refers obliquely to a USR, the whole document needs to be disclosed. We have disclosed it with redactions. The third point is that although, as Mr. Lewis explains, Standard Chartered accepts that the US SAR documents evidence certain issues concerning potential Iranian sanctions breaches, such as the use of shell companies or online banking transactions for Iranian IP addresses. Your Lordship will appreciate that the making of SARs is an extremely common day-to-day occurrence for a large global financial institution. The making of a SAR itself doesn't establish wrongdoing by a customer, still less by the bank. And the fact that a bank submitted a relatively small number of SARs, which might evidence potential breaches of Iranian sanctions, would not of itself, in our submission, be regarded as evidence establishing more wide-ranging systems and controls failings. And importantly, we submit, one must take a step back and consider what is actually in dispute in this case, because there is no issue between the parties as to whether the misconduct found in 2019 settlements took place. So it's not one of those cases where there's a dispute about those facts. The real issue between the parties is one of PDMR knowledge. And we do say that it is not likely that SARs submitted by the bank in the ordinary course of business would themselves typically come to the attention of PDMRs of SC plc, the holding company at that time. Indeed, one would expect restricted circulation of SARs consistent with the strict rules of confidentiality under US law to minimise the risk of inadvertent uncontrolled disclosure rather than widespread dissemination within the banking organisation. The judge's analysis on the probative value of the USR documents is at 96 to 98, page 107 to 108. That analysis doesn't refer to any of the points that I've just made. 96 contains no substantive analysis. 97, it's not clear from that whether the judge is actually making any findings there or just recording my learned friend's submissions. But insofar as the judge did accept that SARs are likely to be highly relevant as showing facilitation of evasion of US sanctions by the bank, that conclusion in our submission isn't supportable on the evidence. One would not. On the contrary, the SARs are evidence of the bank reporting suspicious transactions to the authorities. And as I said a moment ago, Your Lordship will have the point already that it's not in dispute in these proceedings that the misconduct found in the 2019 settlements took place. So then one comes to 98, where the judge does see, and the end of 97, where the judge does seem to have placed weight on the fact that a PDMR may have seen the US SARS or references to them in the context of the US authorities' investigations, which ultimately led to the 2019 settlements. But even assuming that's correct, we would submit that that would only matter if PDMR knowledge of the existence or contents of SARS was itself likely to be important to a fair trial. And that's so in circumstances where, for example, all the other material generated in the course of the 2019 investigations, subject to CSI and privilege, will also be available, showing, to the extent that that was communicated with PMR, showing what their knowledge of the status of the investigations was. And it does not seem likely in our submission that PDMRs involved in the Larch investigations being the investigations that led to the 2019 settlements, would be aware of SARS and nothing else, as in none of the other regulatory material. And in those circumstances, we do say it's inherently unlikely that PDMR knowledge of those SARS would themselves be material, still less important to the determination of the question of PDMR knowledge in relation to the underlying misconduct. There is a criticism in the claimant's evidence, and I think I'll just make this point and then finish, about Mrs. Lewis's evidence that the USR documents do not evidence any PDMR knowledge of the falsity of the alleged representations. And they say that's a conspicuously narrow formulation. But the point there, my lords, is that even assuming a PDMR was aware of the existence or contents of the SARS, for example, by reason of their involvement in the 2019 investigations, it simply doesn't follow that the additive knowledge that they would have through their knowledge of the contents of those SARS would either lead to the published information itself being false or incomplete, or still less a finding that a PDMR would know that was the case. And we do submit that the suggestion that seems to be made that awareness of the SARS themselves, as opposed to any of the other material generated in the 2019 investigations, would lead to a finding that a PDMR knew published information was untrue, misleading or incomplete, when that finding could not be made on the basis of other material. That we submit is fanciful, and that really does show why in our submission US SARS as a category are not important to a fair trial. Your Lordship will have seen from our skeleton, we do take a point about the judge's approach to the balancing exercise and his starting point that there's a heavy weighting. We do submit he was wrong to take that approach. I'm going to leave those points on the page, if I may.
Yeah.
And in relation to CSI documents, I think we've dealt with the committee point at some length in the course of exchanges with the court this morning. So I think I can content to leave that as it is. In relation to relevance, my lords, you have our submissions in the skeleton on the CSI documents and their relative lack of relevance. I don't have time to develop the points, but one of the fundamental points in relation to that, my lords, is in relation to CSI categories 1 to 3. That is the examination reports relating to the bank's New York branch, responses to the examination reports, and monitor reports. So the reports prepared by the monitor, who was appointed pursuant to the 2012 settlements, are very much in a different category from the category 4 documents in terms of exchange between the regulators, because they relate to the day-to-day supervision or the implementation of the remediation programme under the 2012 settlements, as I said at the beginning. And the 2012 settlements themselves and the remediation programme is not something that forms part of the claimant's case. So unless I can assist you further, I know I've indulged on the patience.
I think you've done very well to get in what you have, Mr. Allen. So thank you very much, and we'll come back at 2.
Court rises, please.